our panel session will actually be run very similar to the way in which they were run earlier this morning, where we'll be sitting right there and encouraging discussion. Our panelists will also have something to say and impart to us, because we're all here to get some information. I'm here to ensure that you get your information as well. But before we jump into it, there are two small matters. My panelists, I'm told, because we're using the same format as this morning, we'll need to get our earpieces. So I'm asked to ask you to make your way over here to get the earpieces. In the meantime, the organizers of this conference have come up with a brilliant idea to wake everybody up. I thought I could simply get you to stand and stretch. However, they want you to expand your lungs and blow up the balloons that were given to you. However, there's an absolutely wonderful and delightful surprise at the end of that, should you participate. So how many people have balloons while my people get their earphones? And remember, I'm to get one too. Yes, it's a competition too. We need to see who can blow them up quickly. Let's go. And there's a particular balloon that I'm looking out for, I'm told. Do not blow them till they pop. Apparently there's a winning balloon, so there is for a prize. But I'd like to get 30.
Thanks, William.
Portia, has anyone chosen the winning balloon as yet?
It's probably this one that I haven't blown up. No.
Thank you.
Sometimes it's all.
Thanks. So, hold up. It's already on. Oh, fantastic. Okay. Have they chosen? I know, but I'm not seeing it.
Okay.
Ah, no. I'm only giving 2 more minutes. And then, oh, okay, we see the winning balloon. That is the winning balloon. I'm told that the prize is, and you have to listen very carefully, it's lunch at the Dove restaurant, and it's a lunch for 2, and you're invited to take the person on your left. I know that the person on your left is married, so you may have to get prior permission. Great, so hopefully we're now awake, so we can jump into this topic. I think it's a very interesting topic. We're getting into the meat of the matter, I think. Many of us here deal with transactions every day, and we'd like to see how we can incorporate various, well, I shouldn't say various, but arbitration clauses, arbitration agreements in our transactions. So my panelists here will have some information to give to us, and I'm going to call each one by name. I'll ask them to give a 30-second introduction because the at-length biography was on the website. So we'll just have a quick introduction for ease of reference, and then they'll give us some information. I will then facilitate questions after they've given their respective presentations, and I may have some questions on my own. I'm also told to keep on top of time. So if you have your questions, please jot them down and hopefully ensure that they're succinct questions which get information out, and not necessarily one of those questions where you actually end up giving the answers. Okay, great. So I just gave a good introduction. May I ask Ben, love, to jump straight in? Tell us a little bit about yourself, and I know that you were going to give us a general overview on the best practices in drafting arbitration agreements.
Yes, my name is Ben Love, and I am a senior associate in the New York office of Freshfields. I spent the past 5 years in the Paris office, and before that I practiced with King and Spalding in Houston. My practice focuses entirely on international arbitration with a fairly healthy mix between investment and commercial arbitration. Do you want me to go ahead with my presentation?
Yes.
All right. So I'm delighted for the opportunity to speak here today. The BVI looks to be taking all of the right steps to becoming an international arbitration hub, and it's an honor to take part in that process. So what I'm going to talk about are the basic considerations that a transactional lawyer must have when approaching the task of drafting an arbitration clause. And the first question you might ask is why this matters. Arbitration clauses tend to get inserted into contracts at the last minute, and so they're often written in a rush without much consideration. It's often even a cut and paste job. And I think if I can get one message across, it's that arbitration clauses do matter. They should not just be a cut and paste job, and the task and the difficulty of doing the task properly should not be underestimated. The arbitration clause is the mechanism that gives the contract teeth, and in particular international currency through the enforcement mechanisms of the New York Convention. One might recall Justice Holmes' observation in the Western Mate case before the U.S. Supreme Court, in which he said, and I quote, "Legal obligations that exist but cannot be enforced are ghosts that are seen in the law, but that are elusive to the grasp," end quote. So on the assumption that all of us here, whether we're parties to contracts or the lawyers who draft those contracts, are not intending to make legal ghosts when doing so, I will set out some of the important considerations in drafting an effective arbitration clause. This process can be broken down into 5 parts. The first being the seat, the second being the selection of the arbitral rules, the third being the mechanism for appointing arbitrators, the fourth, the governing law, and fifth and last, but only if absolutely necessary, bells and whistles to tailor make your arbitration clause for the particular contract in question. Before going through each of these, I'll stipulate a couple of overall drafting points. The first is that the preferred word when stipulating that disputes are to be decided by arbitration is shall, not may. Most national courts have interpreted may as shall in the context of arbitration agreements, but it doesn't hurt to be absolutely clear about the matter. And also the disputes that should be arbitrated should be referred to as any or all disputes, or if you want to cover both bases, you could say any and all disputes, to make it absolutely clear that disputes arising out of or in connection with the contract are to be arbitrated and not taken to local courts. So with those stipulations, let's start with the first question when drafting an arbitration clause, and that is the seat. You will want to ensure that the seat of arbitration has local courts that respect the arbitral process and will not unduly interfere in the arbitral process, a subject that we've just heard quite a bit about, and that the local courts have a mechanism for enforcing arbitration agreements, whether that be through anti-suit injunctions, a stay of court proceedings, or otherwise. You also want to see that the seat of arbitration is in a country that is a party to the New York Convention. The New York Convention is the mechanism that gives your arbitration clause and thus your contract international currency and in terms of being enforced or enforceable around the world. You'll also want to consider the applicable mandatory rules of the seat of arbitration. Now, most arbitrations are governed by procedural rules of particular institutions, but those procedural rules are incapable of overriding mandatory rules at the seat. So you want to know what those are before you choose your seat. Another consideration when choosing the seat is convenience. You want to consider the cost of arbitrating in that seat and the convenience of clients and counsel getting to an arbitration in that place, as well as the knowledge of counsel in dealing with that particular arbitration law. You also want to consider issues such as logistical support, the political climate, and the safety of the seat. And with all of these considerations historically, as has been mentioned by others in this conference, the most popular seats are places like Paris, London, New York, Geneva. I think with the enactment of the Arbitration Act, we may see more arbitrations here in the BVI as well. So that's it for the seat. So once you've chosen a good seat, you also need to choose a set of arbitral rules. The other option is to have an ad hoc arbitration that is not governed by any rules or governed by bespoke rules, but that is not to be advised. And the safest and most predictable manner and the best practice is to choose a set of institutional rules. The most popular institutional rules today are the ICC rules and the LCIA rules, and coming in at, I think, a fairly distant third are the ICDR rules administered by the American Arbitration Association. And all of those rules are administered by particular institutions. One might also choose the UNCITRAL rules, which are not necessarily administered by a particular institution, though the PCA does have some role in ensuring that those rules operate smoothly, especially with respect to the appointment of arbitrators. But any of the four sets of rules I've just mentioned, the ICC, the LCIA, the ICDR, or the UNCITRAL rules, are a good choice for just about any arbitration, and most of the differences between them are not material, although it is important for any particular case to consider the particular features of those rules when drafting your clause. So once you've chosen a set of rules, then you need to choose the mechanism for appointing the arbitrator. Most of the rules or all of the rules that I've just named have such a mechanism, but the mechanisms do differ from institution to institution, and so to the extent that you want party control over the appointment process, it's best to be clear and explicit in the arbitration clause. And arbitrations are typically decided by either one or three arbitrators. A good rule of thumb is if it's a large volume contract that's likely to give rise to disputes over $10 million, to stipulate that the dispute will be decided by three arbitrators. If it's a small contract and the disputes are likely to be under $10 million, the choice of a single arbitrator is often more cost effective. And when stipulating the rules for appointing an arbitrator, parties are often tempted to place qualifications on the arbitrators that can be appointed. This is not usually to be advised. In some cases, it may be acceptable to stipulate that parties will not be from a particular country if political neutrality is required, but in general, you are asking for trouble and perhaps a pathological clause when trying to stipulate beforehand the qualifications that an arbitrator must have. So fourth, you want to set a governing law for the arbitration clause. And this is an important point because in many contracts there is a governing law for the interpretation of the contract, but in many jurisdictions it is unclear whether that choice of law also extends to the arbitration agreement, or whether the arbitration agreement will be governed by the law of the seat of arbitration. So it's best to make this clear in advance and to stipulate a choice of law that expressly applies to the arbitration agreement if you want predictability about how that arbitration agreement will be interpreted. The governing law that you do choose should be internationally respected and understood. Common choices of law are English law or New York law, not U.S. law, but the law of a particular state, typically New York, or for civil law contracts, French law. And when choosing particularly applicable law, you want to make sure that it is compatible with the contractual expectations of the parties, and that, as I mentioned before, the mandatory provisions of that law, or the mandatory provisions of the seat of arbitration are also compatible with that law. And fifth and last, but as I mentioned, only if necessary, you may consider certain bells and whistles to add to your arbitration clause. But in most cases, you won't want to add any sort of tailor-made provisions to your arbitration clause. You would rather have a standard form arbitration clause as listed in most of the institutional arbitral rules. But if you are intent on bells and whistles, you might have staged ADR, which requires mediation or negotiation before the arbitral process. You might stipulate that the arbitration be confidential, or that a fast-track procedure is available. You might also consider stipulating the scope of acceptable discovery in the arbitration clause. You might also consider defining the role of courts, in particular with respect to interim measures in relation to the arbitral process. But as a general rule, none of these tailor-made provisions are necessary, and when drafting arbitration clauses, you should keep it simple. Thank you.
Thank you, Ben. Sarah, welcome you to go ahead.
Thank you. So just to briefly introduce myself, before I joined Appleby, which was 5 years ago, I was an associate in the London office of DLA Piper, and for the last 2-3 years of my time there was largely concerned with arbitration, international arbitrations in London and Stockholm, as well as elsewhere. I'm going to slightly develop on what Ben's been talking about, so some general principles of drafting, and then also hopefully move into some practical tips on what not to do, with some examples of what people have done in the past that have gone horribly wrong. So first principles, other than those elements of the clause that Ben has mentioned, firstly, what your arbitration clause obviously wants to do is produce mandatory consequences for the parties. This goes back to something Ben mentioned about having shall rather than may. Secondly, you'll be wanting to exclude the intervention of the courts so far as possible, at least before the issuance of the award. Thirdly, to give powers to the arbitrators to resolve disputes that are likely to arise. And lastly, to put in place a procedure to lead to an award that's judicially enforceable. The problem, of course, with badly drafted clauses, and this has been touched on by various of the speakers today, is that what it will do is increase cost and time in procedural fights before you actually get to deal with the substantive issues of your dispute. The courts of pro-arbitration jurisdictions, which I think we can say we are definitely in BBI, will generally do all they can to help badly drafted clauses become operative. But there are, of course, situations in which the drafting doesn't allow that to take place. So to deal with some examples of common problems, first of all, dealing with the first point of general principle is where the clause does not make arbitration mandatory. And this goes back to the may versus shall problem. May or using may in your clause brings an initial doubt to the question as to whether the parties even intended mandatory arbitration in the first place. Second problem, or commonly found problem, is references to institutions that don't in fact exist, or to institutions that do exist but are misplaced or mislocated by the parties in their clauses. Often an example given is the mislocation or misplacement of the ICC, which people obviously don't always know is in Paris. A particular problem with that might be if you refer to the ICC but you refer to it, for example, as being in Stockholm, which will bring questions of are you intending to refer to the ICC or are you intending to refer to the SCC. As an illustration, following on from that, of how institutions will try to assist the parties in perhaps correcting such errors, the ICC has accepted references to itself where it has been referred to variously as the International Commercial Arbitration Association, the Official Chamber of Commerce in Paris, the Arbitration Commission of the Chamber of Commerce in Paris, and a Commission of Arbitration of French Chamber of Commerce, Paris. So we can see various differences, but the ICC has stepped in and assisted. As an admonishment to that is it's obviously quite an easy thing to check when you're drafting your clause. So something to make sure of, that when you are referring to a particular institution or a particular place, that you do get its location and its name correct. Thirdly, something Ben also touched on, there may be an inclination or a wish to tightly define or tightly specify who your arbitrator is going to be or what their qualifications need to be. And the problem, of course, with doing that is that you might make it much more difficult when it actually comes to a dispute to find someone that meets all of your criteria. An example that I have here is parties who wish to appoint a Chinese-speaking arbitrator with a French law degree and a familiarity with Middle Eastern construction contracts. Now that, you can imagine, is going to take some time to discover that person, and if you do eventually discover that person, you might find that they're not suitable for all kinds of other reasons, despite the fact that they fit those three very particular requirements. You also will find occasionally arbitration clauses that are inherently or internally inconsistent. One example I have is an arbitration agreement that's subject to English law with a seat in Glasgow. Lastly, and the most lengthy, but largely because I have a fairly lengthy quote from a very long arbitration clause, are multi-tiered clauses. And this is something Ben also touched on, and I think was touched on earlier when talking about party autonomy and the wish that there is sometimes to put in those very particular clauses because you feel that your circumstances are unique or your dispute might require some unique provision. And those multi-tiered clauses, unless they're extremely tightly drafted and extremely carefully drafted, can lead to endless pre-arbitration litigation about what they actually mean. And I have one example that actually comes from Anguilla, and I'll just read the first part of it. Two fairly long paragraphs there are before we even get to any mention of arbitration. The first of those, and I quote, if any dispute arises between the employer and the contractor in connection with or arising out of the contract or the execution of the works or after their completion, and whether before or after repudiation or other termination of the contract, including any dispute as to any opinion, instruction, determination, certificate, or valuation of the engineer, the matter in dispute shall first place be referred in writing to the engineer with a copy to the other party. Such reference shall state that it is made pursuant to this clause, no later than the 84th day, after which, the day on which he received such reference, the engineer shall give notice of his intention to the employer and the contractor. Let's stop, so we don't even know what that sentence particularly means. such decision or intention shall state that it's made pursuant to this clause. I won't read the rest of it because it does go on, but stopping there, we have a huge potential problem already because the engineer is a defined person who was involved in this construction project, I think it was. He was an employee of the contractor on the project. The dispute arose, of course, after the project was finished. There is no longer an engineer. So your very first step before you reach arbitration is to try and refer a dispute to someone who no longer exists, which is just, I think, an illustration of why being, one, particular about who you're referring your disputes to, or overly particular about who you're referring your disputes to, and two, putting in place various levels of pre-arbitration resolution attempts is really just asking for trouble, largely. In conclusion, because I won't read the rest of that, I agree entirely with what Ben said. It really must be repeated again and again that these things are far better kept very simple.
Thank you, Sarah.